Swayam Prabha. Digital India. Educated India.
Hello, Namaste. I am Dr. Diksha Munjal Shankar. I teach as an assistant professor at the Faculty of Law, University of Delhi. So, we will be starting out with lecture 2, which will talk about residence and scope of total income. Yesterday, when we were discussing lecture 1, we discussed about how we look at the basic concepts in taxation. We looked at certain important definitions, and we had discussed the concept of application and diversion of income. So today we will take it forward from there and understand how is it that we are able to understand who is liable to pay tax on the basis of their residency. So today we will be basically discussing 3 main topics within residence and scope of total income. First, the determination of residential status of an assessee. Second, we will be looking at the concept of total income of the assessee. And finally, we will talk about the income that is deemed to accrue or arise in India. So let's start first with the determination of residential status of assessee. So when we talk about the residential status of assessee, we are not looking at the concept of whether or not you are a citizen of India. So you may or may not be a citizen of India, and you may well be required to pay tax in India. So let's look at that in greater detail now. So assessees' incomes are liable to be charged to tax in India either on the basis of their residential status or on the basis of source of income in India. The residential status for the purposes of tax, however, must not be confused with either nationality or citizenship. The residence of a person has to be determined with reference to a particular assessment year. Since the assessment year follows the previous year, it is in fact the particular facts and circumstances of that previous year on the basis of which the residence status is determined. So while the residence-based taxation of an assessee is on the basis of physical presence in India, that is, the number of days spent in India or the control and management being in India, source-based taxation is applicable when the assessee's income earned has an economic nexus with India. So you will see that for different sort of categories of persons, which we had discussed in the previous lecture, there is always going to be a difference in terms of how you will find out the residential status, right? So if there are people like you and I, individuals, it's very easy to find out whether or not you were present in the country for a particular duration. So for X number of days, whether you were there in the country or not, right? But then there are certain body incorporates for which it is nearly impossible to find out. And therefore, we have a different criteria for them. Apart from that, there might be certain situations wherein you've got assessees who do not have a residential status but are deriving their income from some sort of source within India. Now, it does not matter how you are tapping into this resource. So, if you tap into the land, air, water, human resource, any resource which is located in India, and you are earning an income out of that, it will make you liable to pay tax in India. So the IT Act recognizes both residence-based and source-based taxation under Section 6 and Section 9 respectively. For the purposes of determination of residence, Section 6 divides the concept of person into 4 broad categories. First is an individual. Second, an HUF, that is a Hindu undivided family, firm or AOP, also known as Association of Persons. Third, a company. And fourth, every other person. So these 4 categories may then be divided further based on their residential status as ROR, which is a resident and ordinarily resident in India, RNOR, which is a resident but not ordinarily resident in India, and NR, who is a non-resident in India. So now we will look at whether an individual would be considered as a resident or non-resident. So when we look at whether an individual is to be considered as a resident or non-resident, we will look at two basic conditions, right? So if you fulfill the two basic conditions, then we will say that you are a resident. What are those conditions? First is that if you have stayed in India for 182 days or more during the previous year, right? So let us say, for example, you are in the year 2001, 2, right? That is your previous year. So if you have been in India, you have stayed in India for 182 days or more, then we will say that you have been a resident in India, right? Or alternatively, we will go back 4 years in time, right? And we will look at your preceding previous years. So what will be the preceding previous years? They will be 2000, 2001, 1999, 2000, 1998, 99, right? So these are going to be your 4 preceding previous years, right? So let's look at the second condition where it says that the person has stayed in India for 365 days or more during the preceding 4 years and stays in India for at least 60 days during the previous year. So if the individual does not fulfill any of these basic conditions, then the person will be treated as a non-resident, right? So if you fulfilled either condition 1 or condition 2, we will simply say that you are a resident. But if you do not fulfill any of these conditions, none of them, then we will say that you are a non-resident, right? Now we will further subcategorize and find out whether this resident is to be treated as a resident ordinarily resident, or do we treat this person as a resident not ordinarily resident. So when we find out whether a person is resident or not, we will further divide. To be able to do that, we will look at 2 additional conditions. What are those 2 conditions? First, that an individual would be considered as a resident and ordinarily resident if he fulfills the additional conditions. 1. He has been a resident for 2 out of 10 PPYs and he has been in India for 730 days or more during the 7 PPYs, right? So when I'm talking about 10 PPYs or 7 PPYs, we are simply looking at preceding previous years, right? PPY. So just the way we looked back in time for those 4 PPYs, over here we are looking back in time either at 10 PPYs or at 7 PPYs, right? So we will first find out whether you've been a resident in India for 2 out of the 10 PPYs, and if you have been, only then we will move to condition number 2 and find out whether you've been in India for 730 days or more during the 7 PPYs, right? So if you fulfill both these conditions, mind you, when we were looking at this stage, which was stage 1, we were looking at conditions 1 and 2, out of which you could fulfill either of them, 1 or 2. And over here, when we are looking at this stage, which is stage 2, we are saying that you've got another set of additional conditions, but over here you have to fulfill condition number 1 and condition number 2, okay? So thus, if the individual fulfills both the additional conditions together with either of the basic conditions, he would be considered as a resident, ordinarily resident for the purposes of taxation. If the individual fulfills either or both of the basic conditions and only one or none of the additional conditions, then he would be treated as an RNOR, which is resident, not ordinarily resident. So when we talk about those first two conditions, which are your basic conditions, there are certain exceptions to it, right? So let's look at those exceptions. First, if an individual falls into any of the following exceptions, then the basic condition which provides the threshold of 60 days stay in a given previous year is replaced with 182 days. So basically we are trying to say that if an individual falls in any of the following exceptions, only condition number 1 is applicable on him. If their stay does not exceed 182 days, they become non-resident. So what are those exceptions? Those exceptions are as follows. First, an Indian citizen leaving India in any previous year as a member of the crew of a Indian ship. So if you are leaving India as a member of the crew of an Indian ship, then we don't know when you're going to come back, right? So when you come back is not something that we can foresee or we can calculate at all given points of time. Not to say that you cannot, but usually you might be in a state wherein you are not able to calculate, right? And therefore, to prevent any sort of situation where we are left, wherein we are not able to calculate, therefore we have put this situation under an exception. Secondly, an Indian leaving India in any previous year for the purposes of employment outside. So let's say, for example, you have sought employment outside of India and you're leaving for the purposes of employment. Now we do not know when you're going to come back. If we do not know when you're going to come back, then how do we find out your resident status? And therefore we put this situation also within the exception to the basic condition. And finally, an individual being a person of Indian origin comes to visit India in any previous year. So who's a person of Indian origin? An individual is deemed to be a person of Indian origin if he or either of his parents or his grandparents were born in undivided India. So now that we have looked at the status, the residential status of an individual, we will now look at the residential status of a Hindu undivided family. So when we look at the residential status of a Hindu undivided family, again we will categorize this HUF into either a resident or a non-resident, and then if you are found to be a resident, we will again further subcategorize and find out whether you are a resident ordinarily resident or a resident not ordinarily resident. So let's look at that. So the first step over here is to determine whether the HUF is resident or non-resident. So again we are looking at stage 1, which is applicable only for Hindu undivided family, right? So how do we do that? So to find out whether an HUF is resident or not, we will see if 100% or part of the affairs of HUF are controlled or managed from India. But if 100% control and management is from outside of India, then we will clearly say that you are a non-resident, right? So to be able to find out whether you are a resident or non-resident, what is the basic criteria? We are basically looking at control and management. So where is this control and management? If it is in India, whether it is there partly or 100%, we will say that you are simply a resident. And if the control and management is 100% outside India, then we will simply say that you are a non-resident, right? So if we find out that you are a resident, then we will move to stage 2 of finding whether or not you are a resident ordinarily resident or resident not ordinarily resident. So how do we do that? Who is the face of a Hindu undivided family? So we've learned all along that in case of a Hindu undivided family, the Karta acts as the representative or as the Karta Dharta as we call for the entire family, right? And now to be able to find out whether this HUF is resident ordinarily resident or resident not ordinarily resident, we will look and identify what have been the activities of the Karta, and we will attribute whatever has been the status of the Karta to the entire HUF. So let's look at that. So to be able to find out whether the HUF is a resident ordinarily resident or not, we will see if the Karta fulfills both the additional conditions, right? So we had done basic conditions over here in case of individuals. Same similar basic conditions we see in case of HUF, but over here we are not looking at the duration of them being in India, right? Over here we are only talking about control and management, right? But when we look at the additional conditions, these additional conditions will be the same as which has been there for individuals. So again, to be able to find out whether you are a resident, not ordinarily resident, we will look at the instance wherein you have been there for a particular duration for 7 PPYs or 10 PPYs. We are going to pick up the same criteria and apply it in case of who? In case of the Karta. That becomes the most important part. And if you fulfill both the conditions, both the additional conditions, then we will say that yes, you are a resident, ordinarily resident. But if you do not fulfill any of the conditions, or if you fulfill only one of the conditions, then we will say that you are a resident, not ordinarily resident. So when we look at this step 2 to determine whether the HUF is ROR or RNOR, the onus of proving that the control and management was wholly situated outside of India is on the assessee, right? So who's the assessee over here? The assessee is going to be the HUF, right? Because it is the HUF's income that we are going to assess, and whoever's income we are going to assess will be referred to as the assessee. What happens when we need to find out the residential status of a firm, AOP, BOI, local authority or AJP? We cannot identify one singular person or a singular individual and attribute whatever the person's activity has been to the entire firm, to the AOP, to the BOI, etc. So over here, to be able to find out the residential status, we find out where is the control and management from. So in all of these cases, we see first that if you are to be considered as a resident, we will see whether 100% or part of the affairs of the HUF are controlled or managed from India. If they are controlled and managed from India, then we will clearly say that you are a resident. But if 100% of the affairs are managed from outside of India, then we will say that you are a non-resident, right? So over here, 100% of affairs are managed from outside India. But if even a small part of it, or of course the entire bit, is controlled and managed from India, then we will say that you are a resident. And now we will look at company. So previously we would have probably picked up company and put it with this firm, AOP, BOI, local authority, AJP. But now we have a slightly different way of looking at companies. So one way of finding out whether a company is resident or not is of course to find out whether the company is registered in India. That's a very clear-cut way of finding out whether you are a resident company or not. If not, if you're not registered in India, then what do? Then we will find out what is your place of effective management. If your place of effective management is India, then we will say that you are resident company. If not, then you are a non-resident company. Therefore, if you're not registered in India, or if your place of effective management is not India, then we will say that you are a non-resident company. So, how do we find out this concept of place of effective management? So, what happens is we usually call it as POEM, right? Place of effective management. And how do we find out this place of effective management? So, what used to happen was that there used to be a lot of sham companies that used to be opened up, or what the companies used to do was they used to get up, go hold their board meetings outside of India, and then contend that they are not having their management in India. Their control and management is not in India, right? And therefore, we have moved out of the zone of control and management in case of companies, and now we look at it in a slightly different way, which is known as the place of effective management. So now we're not looking at what is your or where is the head or brain of your company. That's not the criteria. We are finding out whether your place of effective management is India or not. So for that, the mere formality of holding board companies or board meetings at a place is not conclusive for determination of place of effective management being located at that place. If the board has de facto delegated the authority to make the key management and commercial decisions for the company to the senior management or to any other person, the company's place of effective management will usually be the place where these senior managers or other person who make those decisions, they are located. And with the increase in modern technology and lowering of digital borders, it is no longer necessary for the persons taking decisions to be physically present at a particular location, right? So we've all seen through COVID that with modern technology, you can be present anywhere, right? And that has again been transposed even into the corporate sector, wherein you are not required to be there, where the board meetings are being held across the borders. People might be sitting in different places, right? So physical presence is no longer the criteria. So in such cases, the place where the directors or persons taking the decisions or majority of them usually reside may well be a relevant factor for determining the place of effective management. So let's look at this case of VVRNM Subbiah Chettiar versus CIT. So over here in this case, we are basically going to discuss what is the residential status of an HUF in a particular set of facts and circumstances. So in this case, what had happened was that the Karta of the Hindu undivided family, he was living in Ceylon. Okay? So Ceylon essentially is nothing but present day Sri Lanka. He had visited India during the previous year on various occasions to attend to a litigation, which was his personal litigation, and he was in India for a total of 101 days. The assessing officer had assessed the HUF as a resident on the ground that the Karta was in India for 101 days, and therefore the HUF could no longer be said to be wholly managed from outside of India during the previous year. The Karta had filed an appeal stating that he was in India due to a personal litigation matter and not for the purposes of HUF business. The Supreme Court in this particular case had held that the mere presence of Karta in India for a part of the year in itself is not sufficient to shift the control and management partly to India. And the court also said that the onus of proving that the control and management of affairs lies wholly outside India is on the assessee. In the absence of such a proof, an HUF would be considered as a resident by default. So if you are not able to prove that your control and management is not in India, then by default we will say that, well, you are a resident HUF. And that's a very important takeaway that we have from this particular case. So since the HUF in this particular case was not able to prove that the Karta did not take any decisions for the HUF while attending to his personal work in India, the HUF will be considered resident by default on the grounds of onus of proof. Let's look at another case. This case is called the Narottam Parekh Limited versus CIT Bombay City, and over here the assessee company was basically a subsidiary company of the Scindia Steam Navigation Company Limited, and its business was stevedoring in Ceylon. Okay, so Ceylon again we now know is Sri Lanka. So stevedoring is basically an activity wherein cargo is loaded and unloaded from a ship. So there are huge cargo ships which are there, and this particular assessee company was carrying out such a business where there was a loading and unloading of cargo. So this particular company was registered in Bombay, and its registered office was also in Bombay. The meetings of the boards of directors were held in Bombay, and also the meetings of the shareholders. Now, two managers, they had two power of attorneys looking after, for the purposes of looking after the affairs of the assessee company in Ceylon. The widest possible power and authority had been conferred upon these managers under these powers of attorney. And now the issue was that whether this assessee company was a resident company or not. So when we look at this particular case, we will see that you've got Scindia Steam Navigation, and then it had a subsidiary company, which over here is the assessee. So I'm calling the assessee A, right? I will just mark it here as an assessee, right? So the subsidiary company was A, and what was it doing? It was carrying out its business in Ceylon. Now this particular company which was there, Scindia Steam Navigation, this was in Bombay. Subsidiary company was also in Bombay, registered in Bombay, right? And also it had its board of directors meetings taking place in Bombay. Now the question was that this subsidiary company which is carrying out its functions in Ceylon, where its business operations are, you have given out power of attorney to two people, right? Both of them have got power of attorney. So when they have got power of attorney and they have been given widest powers, okay? So this power of attorney has given them very, very wide power. So power of attorneys, just as an add-on, are of two types. You've got general power of attorney and you've got special power of attorney. When you look at special power of attorney, you give very limited powers, right? But in case of general power of attorney, you have very, very wide powers that you give out to your attorneys, the people who are going to act on your behalf, right? So the company over here had given out power to these two people who were located in Ceylon. Now, if you need to find out the residential status of this particular company, how do you do it? That was in question, right? Because here were these people who were carrying out operations for the company in Ceylon. All the operations are taking place over here. And on the other hand, you've got the registered office and the board of directors meetings, etc. taking place all in Bombay. So then let's see how it proceeded. So the Supreme Court over here held that the head and brain of the company with regard to this particular business was in Bombay and not in Ceylon. Why did it say that? It observed from the minutes of the meetings of the boards of directors, which were also placed before it, that the central management and control has been kept in Bombay and has been exercised by the directors in Bombay. So everything was taking place in Bombay, right? You've got the management over there, you've got all the key decisions coming out from there. So the court said that the head and brain of this particular company is in Bombay, not in Ceylon. Then the court stated that what we have to consider in this case is not the power or the capacity to manage. We are not looking at the power or capacity to manage and the power and capacity to control. We are not looking at that, but the actual control and management, or in other words, not the de jure control and management, but the de facto control and management. And in order to hold that the company is resident during the years of account, it must be established that the company de facto controlled and managed its affairs in Bombay. The court observed that the power of attorney could be cancelled at any time, right? And that they must carry out, the people who were holding the power of attorneys, they must carry out any orders given to them from Bombay. They must submit to Bombay an explanation of what they have been doing, and throughout the time that they are working in Ceylon, a vigilant eye is kept over their work from the director's boardroom in Bombay. So the court over here said that, well, we are not interested how are they managing it? Where is it that they are getting their power from? Do they have their own power? No. The power is also being derived from the source which is in Bombay, right? So we are not looking at how you are managing, where is the actual control and management is what we are looking at. It is basically Bombay, and it is from Bombay that you are deriving the power to carry out your work in Ceylon. So if you are holding power of attorney today, tomorrow power of attorney can be revoked, right? And if that power of attorney gets revoked, who gets direct control anyway? It is going to be Bombay. So if everything is emanating from Bombay, all key decisions are coming out from Bombay, simply because there is this power of attorney which has been given effect to, we cannot say that the control and management is in Ceylon. Control and management continues to be in Bombay. Let's look at now the scope of total income of assessees. So section 4 is the charging section of income tax. Section 4 of the Act provides for tax on total income, while section 5 enumerates the scope of total income. So section 5, which talks about scope of total income, provides for the incidence of tax in India, which is based on the concept of residence. So an assessee who is resident in India is taxable on its global income, while a non-resident is taxable only on those incomes which have a nexus in India, right? So if you are a resident in India, then we are going to tax you on the basis of your global income. Why global income? Because we know that you are residing in India. But when we look at a non-resident, we are going to make you liable to pay tax only on those incomes which have a nexus in India. That means where you can tap and say that, well, this income that you are deriving is because you are tapping into some Indian resource. Now, what kind of Indian resource could it be? It could be anything: land, air, water, human resource, right? You've got capital markets, right? So any of those things, wherever you are tapping, whatever kind of resource you may be tapping into, the moment you have a nexus in India and you are earning some income as a result of that nexus, we will hold you responsible. We will hold you responsible for paying tax in India. So the scope of total income therefore varies according to the residential status of the assessee. The incidence of tax is highest for the resident ordinarily resident, slightly lower for the resident not ordinarily resident, and the lowest for non-resident. So I have tried to put it in a tabular form, and we will see how is it that you are liable to pay tax on the basis of the way income comes into your hand. So we will first look at it from the point of view of India, and these are the different residential statuses. So if your income accrues or arises or is deemed to accrue or arise in India. So yesterday we had discussed if this accrue or arises means the same thing. Essentially they are two different things, but in case of self-taxation we use them interchangeably, and we say that, well, if the income has accrued or arisen, then your income is liable to be taxed in India. right? So income that accrues or arises or is deemed to accrue or arise in India. It has not accrued or arisen, but we will presume as though it has accrued or arisen, right? So deemed means that even though it has not, there are certain situations wherein we will say that, well, we will take it as though it has accrued or arisen in India. So if you're a resident, ordinarily resident, then that income will be taxable. If you're a resident not ordinarily resident, it will be taxable, and similarly in the case of non-resident. Then we look at income which is received or is deemed to be received in India. So the moment income is received in India, whether you are an ROR, RNOR, NR, you are liable to pay tax on that, right? So what do we mean by received? Now there is a difference between receiving income and remitting income, right? So when do we receive? Now let's say, for example, you are employed with your employer X, okay? Your employer has to pay you some amount every month, right? Now if you are employed in India, you are getting some money from X into your bank account, right? So where are you receiving this amount? You are receiving this amount in India, correct? But there might be situations wherein you are employed with employer X who is outside of India. And when you are outside of India, you might ask your employer to send the money in your Indian bank account. The moment the money comes into your Indian bank account, we will say that you have received the money. When and where? You have received the money when it has actually entered into your Indian bank account, and two, where it has been received? It has been received in India. You might be sitting outside. You are in some other country, right, with your employer in that country itself, and the employer is sending the money into your Indian bank account. Then we say that the money has been received in India. There might be a situation wherein you are there, your employer is there, and you tell your employer that, listen, I don't think you should send it to my Indian account. Please send it to me in my bank account of country C. Okay, I'm in country C. Please give it to me over here. When this money has come from X, who's your employer, to you, the money has not been received in India. Why? Because your money has gone to the bank account of country C. Similarly, you might want to now be in a situation wherein you tell your employer that, listen, please send the money to me in my bank account, which is in country C, and then once you take it over there in country C, you send some amount out of that into your Indian account, right? Now when you send it to Indian account, we will not say that the money has been received in India. The money has been remitted, not received, because over here the money was received. Money can be received only once from the employer, okay, or whatever source. The money will be received only once. Once you have received the money, then you will send it out to country X, country Y, to your own country, whatever, right? But wherever the money has first been received, that is where we say that the money has been received. After that, it's only remittance. So when we say that the income is received or is deemed to be received in India, then whether you are an ROR, RNOR, NR, irrespective, you are liable to pay tax. Then we look at situations wherein you are outside of India. So when income accrues or arises outside of India, but if the business is controlled or profession is set up in India, then if you are an ROR or an RNOR, then you are liable to pay tax in India. But if you are an NR, you are not liable to pay tax in India. And for any other case, we mean that apart from a situation where you are getting money from business or profession, that means you are getting some money either from house property or from some sort of capital gain, etc. Then if you are an ROR, then only you are liable to pay tax. If you are an RNOR or NR, you are not liable to pay tax. Then we look at this concept of income that is deemed to accrue or arise in India. So section 9 provides for the income that is deemed to accrue or arise in India. That means that we are looking at a situation wherein, if we look at it from a straight technical point of view, it has not accrued or arisen in India. Not accrued or arisen. But there are situations wherein we will presume as though it has accrued or arisen, right? And that is when we are looking at this concept of deemed to accrue or arise. So section 9 clause 1 provides or addresses the income that accrues or arises directly or indirectly through or from any business connection in India, any property in India, any asset or source of income in India, or transfer of capital assets situated in India. This section is not applicable in cases where the income is received in India or is deemed to be received in India or is accruing or arising in India. This section is relevant where non-resident is paying tax on income. So what do we mean by business connection? So if a person has real and significant or substantial economic nexus through some business connection in India, the income is deemed to accrue or arise in India. The basic concept of business connection is that a non-resident person should be liable to pay tax for the profit that is earned in India. Thus, the non-resident will pay tax on an income which is now deemed to have accrued or arisen in India. The term business connection is significant only for international transactions. For RNOR and NR, the term is not relevant if the income has accrued or arisen or received in India. There are certain significant changes which have been brought into this section, and now business connection includes activities of an agent as well, right? So what happens if you want to get into some sort of a business? You will either jump into the business directly. If you don't want to jump into the business, then you'll probably get an agent on board and try and get that agent to do the activities on your behalf. Either of the cases, whether you want to jump into it directly or you want to get an agent on board, you will first obviously want to try and test the waters and try and understand whether this business will run, right? So let's say, for example, you are a company which has its operations outside of India, and now you want to come here and check whether you can run a business here or not. So you will open up a small liaison office, try and understand whether business is going to work here, not, etc., right? So when you are opening up a liaison office in India, we don't say that you have a business connection. Why? Because you are just simply trying to test the waters, trying to understand whether something will probably work out for you or not. If you find out that, things are not going to work out for you, you will just shut that office and go, right? But you're not carrying out any business activity there. But if you feel that, yes, India is a great market, we are going to do really well over here, then you will proceed, carry out your business, etc. And then you will actually establish a business connection when you actually start out activities. And these activities could either be when you're doing it on your own, or you get some sort of an agent on board to do those activities for you. So let's look at those situations. So the definition of business connection now includes business activity which is carried out in India by a non-resident through an agent. The agent must perform any of the three following conditions. First, the agent has and habitually exercises in India an authority to conclude contracts on behalf of the non-resident, or habitually concludes contracts or habitually plays a vital or principal role leading to the conclusion of contracts by that non-resident. And the contracts are 1. In the name of the non-resident, or 2. For the transfer of ownership or the right of use of asset, or 3. For the provision of services by the non-resident, or 2. He has no such authority but habitually maintains a register of stock in India of goods or merchandise which regularly delivers goods or merchandise on behalf of the non-resident, and 3. Habitually secures orders in India mainly or wholly for the non-resident. Then we say that there are certain exceptions also to these business connections. When there is a business connection established in India by a non-resident, any income generated from such connection is liable to tax. However, there are certain exceptions to the same. That means that while there is technically a business connection established, still we will say that it has not been established. Why? Because it will fall under the exception and its income would not be deemed to be accrue or arise in India. So what are those exceptions? One is when you are shooting some sort of a cinematographic movie in India, either as an individual or a firm or a company. Second, when the non-resident is running a news agency or publishing newspapers, etc., whose activities are confined to collection of news and views in India for transmission out of India. So let's say quickly, for example, you've got channels like BBC, you've got CNBC. These are all international channels, right? And what are they doing? Can we say that they have business connection in India? If you see it from a technical perspective, yes, they have, right? But because they fall within the exception of business connection, we do not say that they are having a business connection in India. Why? Because their work over here is only to collect views and news and then transmit it to the whole of the world, right? And therefore, they will fall within this exception to business connection. Third, business of which operations are confined to purchase of goods in India for export. So why do we do that? Because if we put such businesses which are carrying out basically export works, we are generating a lot of foreign currency for ourselves, right? So the more we export, the more foreign currency we sort of get for the country, which is good. And that is why this falls under an exception to business connection. And then you've got activity of foreign company engaged in the business of diamonds mining confined to display of uncut assorted diamonds in notified area. Okay, so now we will look at this case of Vodafone International Holdings BV versus Union of India. So Vodafone was incorporated in Netherlands and wanted to set up its business in India. And for this purpose, it had hired a consultant basically to identify what are the opportunities in India. To start out a fresh business in India, it would have had to invest a lot, whether you look at it from the technical aspect, the human resource, etc. So Vodafone management was at that point of time advised to acquire an existing profit-making business. And what did it do? To be able to do that, it carried out studies, it studied the markets, it studied the laws, and it identified Hutchison as a potential entity to be acquired, which enjoyed 22% market share at that point of time. Hutchison SR's 67% holding was with CGP Investments, and therefore it was a subsidiary of CGP Investment. Now CGP Investment was registered in Cayman Islands, and Cayman Islands, as we all know, is a tax haven, and it was a 100% subsidiary of Hutchison Telecommunication. So let's look at it from this perspective. Now when we look at Vodafone International Holdings BV Netherlands, we see that this is what it wanted to do, right? This is what it wanted to acquire. And if you look at this Hutchison SR company, which was an Indian company, it was already enjoying 22% market share. This was being held by CGP Investments, right? And CGP Investment basically had a 67% stake in it, right? It had 60% share in the management and control. And then when you look at Hutchison Telecom International Limited, which was based out of Hong Kong, they had 100% stake in the CGP Investment Company, right? So we can say that as 100% it was to be treated as the parent company, right? And then when we look at Vodafone International Holdings BV, this wanted to actually and did purchase the shares of right. So over here we see that it is Vodafone International which wanted to enter the Indian market. So it really wanted to jump and take control of this. Now when it wanted to do that, it first thought that okay fine, let me go and buy CGP investments. Okay? So let's call it wave 1. Right, this was the first wave thought that okay fine, let me buy CGP investment. Once I buy CGP investment, I will get Hutchison SR. But the consultants that Vodafone had consulted, they said please don't do that, because if you are going to do that, you will have to pay a lot of capital gain on your purchase. Why? Because this is an Indian company that you are trying to acquire, and if you are going to try and acquire this Indian company, you will have to pay capital gain on this transaction, right? Which they clearly did not want to. Okay, and they also said that because you will be a foreign company which will be buying another company, right, you will have to pay tax and there will be a lot of TDS also that will be involved at this stage. So to be able to avoid all of this, what it was advised was that Vodafone should buy Hutchison Telecommunication International Limited, and when it does that, when it buys this, it will get this and this free, right? So essentially you were out to buy this, wherein you had a buy one get one free offer, but now over here you are going to buy one and get two free, right? And then you also had no tax liability to pay. Why? Because you were now a foreign company buying another foreign company, and then it was all clean from the tax perspective, right? So India had nothing to do in it. But if you were going to go and buy this particular CGP Investments company, which had a stake in an Indian company, then the Indian market or the Indian tax system would get involved. So Vodafone then went and bought Hutchison Telecom International. When it did that, once the deal went through, the Vodafone company, it started doing its business in India. So now they had started doing the business in India. When they started doing the business in India, income tax authorities sent them a notice. They were like, what are you doing? How can you do it, right? So they said that when Vodafone purchased CGP investment, it also purchased, when you were going to purchase this, when you purchased this, you obviously also purchased this, right? And this you were able to purchase. Why? Because you went and you bought Hutchison Telecommunication International. So they said, technically you have tapped into the Indian resource and you have not paid the tax. Okay. So over here, there was supposed to be capital gain which was supposed to arise at the level of this transaction, and you were supposed to pay tax on that. Now there was this whole demand of roughly 7,990 crores. This was the actual demand initially, right? Now this is a huge sum of money that we are looking at, right? And to this they added on interest, and to this they added on penalty, and now we were looking at a sum of rupees 22,000 crore. And when we were looking at this sum of 22,000 crore, the matter went before the Bombay High Court, right? So Vodafone went to Bombay High Court on receiving this notice from the Income Tax Department, and the Bombay High Court actually ruled in favor of the IT authority. So they ruled in favor of the Income Tax Department. When that happened, obviously the Vodafone company was not very happy about it, right? So when Vodafone was not very happy about it, they approached the Supreme Court, right? So Vodafone lost at the Bombay High Court, and therefore they went to the Supreme Court. Now over here, in case where it went to Supreme Court, the court said that, well, we do not find any problem over here, right? And Supreme Court went ahead and ruled in favor of Vodafone. They said that if you look at the definition of capital asset, then this definition of capital asset says that if there is any capital asset which is situated in India, right? And they said that what is this capital asset that we are talking about? According to the Supreme Court, they said that you are one foreign company acquiring another foreign company, and therefore there is no Indian connection, there is no nexus with India, and therefore Vodafone is not liable to pay any tax. They said that all of these companies, whether you look at CGP, whether you look at HTIL, whether you look at Vodafone International, they said all of these companies are all international companies, and because they are international companies, they were all foreign companies, the court said that, well, section 2 clause 14 over here is not attracted at all. So section 2 clause 14 is basically talking about capital assets. So they said over here there is no question of capital asset being transferred, right? Now this ruling which was given out by the Supreme Court was really criticized, but then it was criticized not just in India, it was criticized across the board, across the world, that how is it that the Supreme Court could come up with such a decision. However, this matter then went before arbitration, and but till the Supreme Court, we see that the Supreme Court had given a very strict interpretation to the taxation laws, and they said that, well, if there is a problem in our laws, we need to rectify, which actually brought about certain amendments in the Act, but that's where this case actually stopped. So I hope that you have understood the concept of residential status, how total income is to be seen, and how all of this impacts certain transactions even between foreign companies. Thank you.
Hi, my name is Gillette Sam, and I teach sociology at IIT Kanpur. One of the things you must have noticed if you read or if you talk to people around you is that they often refer to something called globalization, or they often say we live in a global world. What does this mean? Today I'll tell you about how to think about globalization or interpret the word global in a sociological manner. When sociologists refer to globalization, they refer to three things. The first is that that it involves transplanetary processes, which means that something is going on across multiple borders, right? The second is that it involves heightened liquidity and interconnected flows. Now, by liquidity, and this is a term that was coined by the sociologist Zygmunt Bauman, we refer to the increasing interconnectedness of things across the globe, but we also refer to increasing instability across the world, which means that potentially something that is occurring many kilometers away from you actually influences the place that you live in. So if there is a natural disaster happening in one part of the world, maybe that causes people to migrate from that area, and they come and settle where you stay. So that is what we mean by liquidity. And of course, when we are talking about liquidity, we are talking about things that are really moving from one place to the other. Now, the third aspect, and this is something that you may not conventionally come across in the way people use globalization, is that of structures. So let's take an example. Supposing I, as an Indian citizen, wish to visit a foreign country. Let's say I want to go to South Africa. Can I just pick up my bags and hop on the next plane and go to South Africa. Any logical person is going to say, no, wait, you need to have documents such as your passport or visa. Now, this passport or this visa is a representation of the larger structure that governs how people move across borders. So, we have things like border control, national security agencies that consider what kind of people are going to move from one place to the other. Correct? So, when we think about globalization, an average person typically tends to think about things moving or people moving from place to place. As sociologists, we also consider that there are structures that facilitate or direct this movement across multiple borders.